All right. Well, welcome everybody. We're very thankful that you guys are here. Hope you started off your new year well. I am Tommy Dutcher with California Title. I'm one half of the host for today. The other half is Mary Jane Morris. And Mary, if you could also introduce our special guest, that'd be awesome.
Yes, I will. Thank you very much. My name is Mary Jane Morris. For those of you who don't know me, I'm the VP of Sales for Granite Escrow. I was specifically brought in to bring broker level problem solving to the escrow world. Many of you know that I was an escrow officer for 20 years from, well, in the escrow field, and for part of that 20 years an escrow officer from about 1980 to 2000. From 2000 on, I have been a managing broker or the broker. So I have a lot of opportunity to solve problems. And so we'd like to be able to do that for you guys as well. Today, very briefly, I'd like to say hello to Tracy from our San Diego territory and Miss Jonna from our La Jolla territory.
Hello.
I am very excited today. I made a special effort to get a date that we could have Miss Nikki Coppa on today. Nikki is, let's go ahead and start the PowerPoint for a second here because I want to bring up her picture and her credentials so that
All right. Give me 1 second.
As well as I possibly can. Nikki's a longtime practicing broker herself. Her day job is she is the compliance officer for all, I believe it's 7 branches now. Yes? Of Century
14.
Up 20 offices of Century 21 Award. Next slide, please. This year, Nikki is the 2021 chair of the C.A.R Defense Strategy Advisory Committee. I'll be interested to hear what that's about a little bit. And then her most recent one before that was the 2020 chair of NAR Risk Management Committee. She is a past board president, and again, she's the current corporate compliance officer for Century 21 Award. There's when I don't know, this is who I call, and I try to keep it light, and I email, and I try to be very careful about what information I send for her. But I know she's going to lay down the law for me when the time comes. Better yet, I'm going to like it. So welcome, Nikki. We're happy to have you.
Thank you so much for having me. I appreciate it.
Today, we're going to be talking about procuring costs. And in our pre-interview with Nikki, and my intentions for today are, as one of the most painful calls a compliance officer or a broker get is a very upset agent who's recently lost a transaction or found out that what they believe they have a procuring cost case on. And what happens to besides defending your files and helping you get your closings done and checking your documents and all that, obviously we care very much that you get paid. It's the most important thing we do. So when we hear that you aren't going to get paid for some reason, we are as disappointed as you are. The reason I wanted to record this today and the formatting for today is I want it to sound very much like what happens when Nikki or I get that call, those kinds of questions. And the reason I want it to record it specifically is because when I get that call, it's often in the middle of the day and the agent is highly motivated for a quick 1-hour class on the phone of what their rights and responsibilities are. And more importantly, they want an immediate step taken of some sort. They want a phone call made. They want some action. And as a person who's for 20 years marketed themselves as a problem solver, and for someone like Nikki, who I was teasing her before class that all her volunteer work for C.A.R is her hobby, besides having a day job. We care very much about you guys getting paid. So could I have the next slide, please? So I want to talk about, this is the legal definition of what procuring costs is. It is, according to Black's Law's Dictionary, the cause originating a series of events without a break in their continuity result in the accomplishment of the prime object. meaning we're going to talk about if you haven't talked to your client in 6 months, that is not a continuous chain of events. Substantially, what we're trying to get to is how did this deal get to be there? So the next slide is where I'm going to ask Nikki to start participating with us. Oh, I'm sorry, one more. So before we get going, I'm sorry, back one, please, Tommy. I'm sorry, you guys. I'm sorry. I'm such a boomer when it comes to switching slides and all that. It was fine until I had 2 screens. Then I don't know where I am. So on the C.A.R website, and we've posted the link at the bottom of this slide, and we've also posted it in the chat. There is a procuring cause, what we call the test. Back in the day, it had true or false, and you could go down and try to decide where you were in the situation. However, very often this is an objective perspective. You may not be taking in everything. And so eventually, I'm probably making I'll do a better job of explaining this, and I'll just give her a second to do that as soon as I finish. They have now checked some of those boxes for you to guide you into what would look like the best chance you have given that test. Nikki, you want to help me out on an explanation of the upgrade of the test?
I think that really originally it was put forward to be able to check a box, whether it's in the procuring or the agent that closed the files favor or the agent that believes they were procured costs. And so that was how it put together so that people could look at a factors to figure out who truly made this transaction happen. And over the years, and just like with everything, there's a lot of mitigating factors that come into play. And there's different trends that go on that we know that mediators are looking a certain way, traders are looking at things a certain way. And so we have to know what gets more weight. There's a lot right now, especially on what the buyer wanted. And so we can fact 24 factors that are, of course, it's great to have that on our side that yes, I did this, not the other agent, but in looking at it, that may not have a whole lot of weight. You have to look at certain things that the hearing panel is going to do, or the mediator is going to listen. And then there are other things that come into play as well that aren't even on here. Where I was just telling MJ, I had a recent one where the mediator said, well, why didn't you pick up the phone when you knew that this client wrote an offer with someone else and call that agent? And the agent had not done that. And he said, you could have started the conversation there and we would have been able to mediate all of this right at that point. And traditionally in the past, that is not something that normally happens. Typically a broker will approach the other broker and have a discussion because oftentimes the agents will get a little heated. And so we kind of try to there. Fact is helpful in understanding the entire picture because most agents believe that take them to the property and then they wrote an offer with another agent. That means I should get paid. And that's not even close to what they look at.
Right. So this is a pretty comprehensive report. And one of the disappointing things that I have is I have to almost give homework the minute I get the call. Please go read this. Please review your notes. We're going to talk about prepping anyway. And very often, I was joking with Nikki when we were doing our pre-interview, is that if I make the call, very often the other guy will tell me something that my agent didn't tell me. And so I'm kind of caught with my pants down a little bit, or I don't quite have the whole story. So when Nikki says pick up the phone, you are the best informed person of the chain of events that brought you to this situation. Part of the reason I wanted to record this class today was so that you can hear us say that we would love to give everybody the 1 hour class when you call. We would love to know your file and your notes as well as you know them. We're not resistant to making the call or trying to help you prepare your case. There's just so many moving parts. And then I have to end the conversation with there's no magic bullet that is positively going to get you a winning case. So we're going to talk about that a little more. So we're not going to exactly role play, but the next slide, Tommy, please.
Oops. One sec.
Sorry, snuck up on you there. It doesn't want to move on. I'll wait. It's
Give me a
just,
second. For some reason, it is stuck. So let me
it's
stop
fine.
sharing
It's
real
fine.
quick and go
So
back.
the next question I was going to ask anyway, and that's what the slide says is, Nikki, hi, it's MJ. I have had a file. I've had a deal stolen. I showed that property until 8 or 9 o'clock. I waited for his mother to show up. We agreed what the price was going to be. I called the other agent. I went home to write the offer, and they called me and said that I'm going to, they're going to write with another agent, or they have written another agent, or I found out that they closed already, which is another point. They do have to close before you can claim anything, because it's not a deal unless it closed. So,
Right.
Nick, where do I start?
Well, first of all, tell me a bit about your relationship with the client. How long have you been working on?
Well,
Why would I have gone to the other person? Did he talk to you at all about seeing others and working with other agents? Do you have a broker agreement? I need to get a good understanding of what your relationship is, both on paper and then from a time perspective and what you've put into it. So that's the thing I'm going to do, is go through and have them explain it. Oftentimes, too, agents walk away on vacation, and not saying that we don't get vacations, but if you leave for 10 days and tell them don't do anything till I get back, that's abandonment. I can't fight that. And that's one of the things that are supposed to be in there. So was it in your conversations? Did they tell you they were to work with someone else? All of those things will kind of come in so that I can get the speed. And I'll ask them to verbally tell me the course of events. They'll go through it, and if it sounds compelling, then I do exactly what you said, MJ, is I send out the procurement. I say, I'm going to send you this chart, different factors. What I want you to do is write your explanation of what happened, okay, looking at the chart, and include everything that you did that's on that chart, because that's part of their statement. If that's what's going to be a hearing panel, then we want to say, did you talk about financing? Did you talk about the neighborhood? Did you talk about loan rates? There's things in you wouldn't necessarily know can come out in your favor. So when did you show the property? When did they write the offer? Kind of things. And oftentimes what I get a lot of is that our agent wrote an offer and then get accepted, and later on that buyer went to the listing agent and wrote substantially the same offer. And so that's where I'll say, okay, substantially, what is substantial? Because your opinion of substantially the same may be very different than what their opinion is. And in looking at that, then unfortunately that's kind of where we get into, if the listing made or whatever to get that deal, then we've got an issue. So we kind of look at what happened and what fault, if any, was truly on our agent. We all lose track of time. We all, miss the boat and don't make the calls that we needed to make, and we don't drop everything on a Sunday when they want to go see something. And that's part of our business, but we also have to understand our repercussions for that as well. So I have them write up their narrative, use factors chart, and then send it over to me, and then we do a call. Okay, at the factors chart, how do you feel? How many do you feel are in your favor? And so then we go through that. And so in looking at that, I will pursue, if my agent wants to pursue, I will pursue them. And they have to pay the mediation fee. As you know, negotiations require mediation before they'll arbitrate. So that being said, you have to file the claim. Okay. I'll usually call the broker first about it. And if we come to some agreement, if not, then the agent does pay to do the mediation, $500 out of pocket usually. And they have to understand that when we go in, a mediation is not win or lose. When you go into a mediation, everybody loses. Okay? No, we are truly just trying to set sure that everybody walks away equally unhappy. And that sounds mean to say, but it's the truth. You're never going to win the whole thing in a mediation. That's the goal. The goal is to get people to stop fighting and
I also
going in.
get, I also find that I get good information there about whatever outrageous thing they were going to say the next time. So very often you will hear whatever the big lie, if you want to call it that, or the big misconception, or even their bullet, even the thing that they think that wins it for them. So very often it's a good place to collect information about what the hearing is going to look like.
Absolutely. And it gives you that opportunity. The one thing about mediation, it sounds bad that everybody's a loser, but at the end of the day, you're standing in an arbitration claim, very rarely do you split the baby. Okay. Meaning that if there's a $10,000 commission, they won't sell, you did 25% of the work, so here's 2,500 and we'll give you 7,500. Usually it's all or nothing. Okay. That is just the way that the decisions are typically made. So going into something, the last meeting I was in, the mediator said something very, very interesting to me. He said, everybody thinks they've got a dunk cake. I will tell you, in looking at all of the percent of your slam dunk. So understanding that no matter how confident you are with your case, you got to put in a 20%. What do you want to do? You have control over the outcome. And the big things about this and is mediation's a lot like what we can do during our transaction to just work through these things. Okay, it's great to have rules, it's great to have rules, it's great of those things, but conversations can change a lot. And having those conversations is incredibly important. You talk to your buyer. When your buyer truly says, she has called me back in weeks, you're not going to win. And you've got to understand that. You've got to be able to take responsibility for what you do right and the things that you didn't do right.
And
At the end of the day, the buyer's going to make a choice. I'm sorry.
Even if, I'm sorry, I didn't mean to interrupt you. I thought you had finished. We didn't, um, even if you did everything right, very often the client will disown you at that point because they've made some, they've gotten a little better price from the listing agent. They've, their agent is upset with them now and they really just want you to go away. And I do very often ask if, when the ones that tell me that the client does feel bad, I will immediately tell them to ask their listing agent for a referral to make up for the for a portion at least. This doesn't make my call any easier because the listing agent, and to be honest, sometimes you're going to be on the listing agent side on a procuring cost case, and and I've seen this 100 times in my career where the listing agent gets hit because nobody else is willing to pay it, and it comes off, winds up coming off that side. But a little bit of something is better than nothing, and it's today, and you can send the referral form. Nikki, what do you think about, and toward the end of my brokering career, we started the conversation with sending them the referral form. Besides our phone call, we would send them a referral form. That seemed to really get us phone calls back, like we're positively not signing this, or that's positively not what happened. Do you think it's wise to attempt that?
Well, I think that part of it is the way, just like what else agents, if you call the other agent and you say, you son of the earth, you stole a client, okay, we're going to have a fight. It's how you walk into something. And so again, I work really hard to have good relationships with other brokers. And MJ and I have had one where we're on opposite things. And guess what? We go, okay, MJ, this is what I've got. So this is what I'm seeing. And she says, okay, well, this is what I've got. And this is what I'm seeing. And we are, it's not a matter of winning and losing. It's about negotiating a solution that everybody that can work with. And I think that that's that same thing. I have something, if I have a buyer broker agreement and I have the narrative then I will email it over along with a, hey, sorry to, hope it's fine, sorry to touch base with you in this way, but we've got something going on, so to talk with you. Here's the BRE and here's the explanation. Do me a favor, take a look, and then give me a ring when you have a chance. And talk about it. Again, you can choose to discuss or you can choose to fight. And for the most part, the brokers that have been around for a while, we all know that we don't want to go through any of these cases. We want to settle things. We want our agents to move on. One of my agents that went through a hearing cause case, we are now waiting arbitration. It's a year and a half. And this is very frustrating. It's taking away some of his vibe. And to have this hanging over for this long, it's just not worth it. But they won't talk. So that's where we are. We have to go through this process. Communication is incredibly key to be able to just have conversations.
On that point, I've spent so many years discovering when a client gets mad, when just a principal gets mad, let alone another agent. And somewhere along the way, it just added up in my brain that anger and fear are two sides of the same coin. So very often, when an agent's yelling at you or for anything, contingency removals, anything, it's because they're having a fear reaction. So very often I do my best to talk that piece down without acknowledging it.
Right.
That this is uncomfortable for everybody and that we're going to listen thoroughly and we want to hear everything you have to say. And whoa, let's just take a minute. Whoa, oh no, how did we get here? To spend most of the time calming the situation down. But it's something I learned. I earned it as I learned it. That anger and fear are two sides of me.
Right. Exactly. Well, and part of that too is that they're emotionally involved. I'm sorry, but a good agent is emotionally invested with that client, and they feel a bond with them. It hurts when someone cheats on you, and that's exactly what it feels like. And so they're emotional, and I get that. And a lot of the conversation is, let's stop keeping score. You can't tell me how many times he didn't return your text and he didn't do this and he didn't do that. Let's just go to the facts, okay? I understand that the emotion's there and maybe slimy, but if we can't prove we're procuring cause, doesn't mean. So getting emotion out is the first part of the first couple calls, is just trying to strip down some of the emotion and get to the actual facts and what we can and cannot prove. And a lot of the work that's done through this, because as much as we say this is business and not for all of us, point.
I think it's a pretty safe sentiment to say that most clients do not understand how emotional we are about their getting what they want out of their home, and how very personal it is. They think that we don't have their best interest in hearts, which is another good technique, which is getting emotional with your client way before it happens, about how much you care and what you're going to do, and that there's nothing they can't tell you. And that, one of my famous lines is, I can't solve it if I don't know it.
Right.
So I positively need to know what the real problem is. You need to be blunt with me so that I can solve the actual problem. Tommy, could I get the next slide, please?
Yep.
So, what's it look like now, Nikki? We've filled out our little test, and just before we move on, I want to mention too that she just made it very clear that these can take a very long time, which is another reason I wanted this class to occur, is because, again, I feel your pain and I wish I could do something quicker, but often I can't. These are disappointing calls, and even if you're going to take it to the mat, it's going to be a while. So Nikki has had us look at the test. Another good thing is sometimes we don't hear about these till later, and they don't know where their text messages are, and they haven't been keeping good records of you know, the emails are one thing, but the text messages are erasing every 90 days or something like that. And you don't have the materials that you need. So given the preliminary conversation with you, Nikki, what comes next?
Using the top factors test, they incorporate everything they did do, make sure that in the complaint, and they put together their timeline of what happened. About texts or emails or offers sent or whatever, then each one needs to be complaint. They're an area. And I look at it, make sure that it all kind of rolls where we need to roll. And they go ahead and file with the local association. Managing broker or broker has to sign off on the filing, and they pay $500, around 500. That's what's around C.A.R. I know there are 750 to schedule the mediation. We belong to 15 associations, and all of them require before going to arbitration if it's between brokers. So mediation first, and what we've done with the pandemic is they've been Zoom, and so mediators that were not comfortable first, so they got very, very backlogged. The file needs to be filed within 180 days when you could know that cause situation happened. So usually like a closing of house or whatever. So you have to file within that amount of time, but the AORs are they're going to do. So that's why the we're in right now is so long. What we try to do is once it's announced, oftentimes that's when the broker will then say, I didn't really do this. Maybe I will have a comment. And so sometimes I've had several of them that settled before we even went, because looking to see if you're going to do something, then fine, I'll talk to you. But if you're not going to do it, then I'm not going to do it. So sometimes I work for me to be able to settle it. And so then I'll have a conversation with the broker. Oftentimes they'll ask the Association of Realtors for contact information and ask to have a one-on-one with the other broker. So that's a great way to get it done. Otherwise, you're going through, most associations will do 2 hours of some will do unlimited up until it settles, and then try to push that. They'll tell you that Zoom are not as effective, in my opinion, because when Ben and me go lunch, to the bathroom, to anything, trying to push it. Really, the more uncomfortable you are, to give from your position. Mediation, very different. You can walk out and go to the bathroom whenever you want to. You're sitting at home in your comfortable clothes. It's very, very different. Discomfortable isn't there. So then when you go to mediation, if you get it settled there, usually everybody, you don't get it settled there, then it's rescheduled for an arbitration. And the associations, very few of them have ever done arbitration. Remember, arbitration binding. It's part of that to have. And, you know, especially if you've been in it before. I've been there before. Being in the room with somebody that hasn't, I definitely have an advantage. And so Zoom arbitration, I haven't yet go there. I'm hoping that we're able to do it when we get into it, because it is very uncomfortable and know that it's going to be all or nothing. You're either going to lose it all or you're going to get it all. The one we have right now, 30 grand. And, you know, my agent knows you're not going to get 10. You're not going to get 15. You're going to get 0. Pay this, this whole experience and given up a year and a half of your life, or get it all.
$1,500 or $1,200 or whatever.
But usually not in arbitration. Usually nothing. 0, you get 30.
Now, even if you were able to come to a number of those commissions are long paid, and the money has to be transferred somehow. We go into standard debt collection there, where we make an arrangement, and are there payments, or
there could be payment plans that can be arranged depending on the association that's handling. Most associations are large to do that. For the most part, a brokerage really takes, and because they're on the line for the, especially for the list agent. So the brokerage will take the hit and do whatever they need to do with their client or with their agent to go ahead and collect that. I've been on both sides of those where our brokerage will pay something out and then have to get everything back. So nobody will do that, but at the end of the day, brokerage is like agent does, so they have some skin in the game there. So sometimes it takes a while.
Um, that can be a very difficult piece, the collection. Even if you win, some of the, I would imagine some of the smaller brokerages don't keep that, don't have a lot of deep pockets to pay those kinds of things, and it does have to be collected up and given back. Once again, just a demonstration that there is definitely a path. There's a legal path available to you, but once again, it's not a straight line. It is a zigzaggy line, and it's frustrating from the broker's position not to be able to make this better for you guys quicker. And I repeat,
one of the things too,
this
and
can't happen unless there's a sold transaction. It has to be closed. Go ahead, Nikki. I'm sorry.
right, you have to have a commission to actually talk about. So until you don't have that commission, one of the things too is that remember that whoever's hearing this, they're a human being, and they have prejudices, biases. They have their own life experience. So you're seeing through your own shield. It seems obvious you were robbed. Okay, but remember the other side is just as convinced that they did nothing wrong. Some human is going to hear both sides and they're going to feel one way or the other. So when we think we have a slam dunk, and that's the big thing that your broker really needs to come in. And I've told my people, I think this is 50-50 at best. I do not think you have enough. And so I would say that you need to start thinking about a referral fee amount that you would be, just don't know. You go in and then you will get nothing else.
I did lift some of the, moving on, Tommy, you were sensing my moving on to the next slide. Thank you, Nikki, for your thoughts. On the procuring cost guidelines that we mentioned earlier, they had some frequently asked questions, and I think you ran right up to the first one, which is, does arbitration always result in an all or nothing award?
Almost always, because in an arbitration, we're doing wrong. We are, is what you have in the whole thing, procure by definition, or you're not. So that arbitrator is going to make a decision. You win or you lose. Now, it doesn't mean they can't do things differently. Result.
This, if you were going to settle, it probably would have come in one of those phone calls or in your mediation appointment or in the period of time immediately following mediation before you go to arbitration, when somebody's fear is rising and they're more motivated to make a deal.
Right.
If you have a buyer broker agreement, do you still have to file a procuring cause case to be heard?
Yes, if you want to, if you believe you are procuring cause, then you absolutely do. But it's huge in the end of everything because you've gone through this with them. If you look at the factors chart, so many things that in that are tied in with your buyer broker agreement. So if you do have one, it is incredibly helpful. And I'll say that that's the one that people will usually talk before we even have to go anywhere. So if I had a broker agreement, I'd call in and say, all right, the deal, we have a buyer broker. And she's going to know, why would I try to fight this? I mean, the ethics, this is all of those that broker knows the other things that you're going to have to fight at that point. So it's best to just buck up and make sure that you're going to pay your penalty and move on. So that's usually a pretty easy referral fee if you do have a buyer broker agreement.
I could back up real quick and do a really basic 1 minute on agency. One of the first tests of procuring cause is agency, and one of the and you know, of course, brokers, especially older brokers like us, older it's more experienced brokers like us, we've been preaching agency from the very beginning. And for those of you who don't know, agency is an advisory. It's not an agreement to pay or anything like that. And so one of the things, Nikki, I wanted your thought on this. So with the new coming soon rules and how you have to have agency to tell certain people that you even have the listing, I thought this was a great time to pitch again for agency. So even if you can't get or if you're not a believer in, or you're not good at it and you don't do buyer broker agreements, stating that what your agency position is early in your relationship does start the signing procedures.
Right.
And is an early test of, even if you never made it to offer, you were clearly, some people wondered if you thought the PED held some similar weight, showing that you had showed them that house. Or
No, what I would have is evidence of how many places I'd seen them, how long I'd been working with them. And there is something to be said, he with the most documentation wins. Whatever you can document. So if I go in and have 20 pieces of paper documenting my relationship with this person, all you have is an RPA, then that's going to weigh more in my favor. But on to your point, right now, having the PEDs out there, it's your perfect opportunity to throw in agency, because you're sending that anyway. You have to have it signed anyway. Throw in agency at that point, then you can say you did do agency. Many agents don't do it because it just feels awkward. What are you going to do? Just send this one form out? And that seems weird, and it's not what they normally do. But because we're doing the PEDs anyway, you might as well throw it out there with the very first one. You've got an agency agreement, and that does bode better for you if this comes to a decision.
very briefly, how do you describe agency? And I do think it's a little more awkward to send it for signature than it is to maybe take it with you and deal with it at your first showing. But what do you tell them if you're just doing just agency?
I think that for me, the way that I always described it is that we're going to go through a lot together. You're buying, and that sounds easy. And there's a long road. There's holes, and what is that you can trust me, and that it is my job to take you through all of it. But your job is to talk with me the whole time. We know what's concerning you, all of that. This disclosure kind of goes through what agency means, and it is my fiduciary relationship with you. I keep I don't tell your secrets that you would go 1,000 more. Okay, that's between you to tell these things, because it tells me how to negotiate things for you and what I need to get down the road. So the more open and honest and comfortable you feel, the better this transaction is. And that's basically what agency means.
I feel like I circle back to agency so primarily in so many situations, and I wasn't going to miss my chance to remind you guys, especially with the coming soon rules to do agency. I think we covered this next question already, but have you seen more than one broker be the procuring cause? And we settled it in mediation or somewhere sooner. Once you've gone this far, it's going to be one or the other. Yes.
If you go all the way and it's actually decided in your arbitration, then one broker would be the procuring cause, usually. I would say 98%, I think the statistics are 98% of the time. It's all or nothing, so you win or you lose. But when you go to a mediation and you end up settling, or you just have broker conversations and you end up settling, nobody becomes the procuring cause. It is simply that we have agreed to share missions this way. Usually there's no guilt involved. There's no admission of guilt, just simply, we'll give you a referral, we'll do this, we'll share something.
And then once again, I wanted to cover the legal determination is predetermination of entitlement, but I call it the slam dunk. Is there a slam dunk procedure or anything I've overlooked here that that comes to mind, other than saying there is no such thing? How many pieces come and go, and how long it takes, and
The more you are with your process, if I go with a buyer and I first sit down and I do their consultation and I have them fill out the BMI, buyer material facts, have them tell what's important to them. We talk about, talk with the vendor with them. If I can show that this is what my standard of price is, and these are the steps that I took with my client, and then they ran off and wrote it with the listing agent, and then that bodes incredibly well. There's nothing that's a slam dunk. I've definitely figured that out. I've lost cases when we've got a claim, whatever, and I'm like, how did that happen? And that's why I say you have to, these are humans going to decide this. It look like that arbitrator's ex-wife, and that's not going to bode well for you. So you never know what you're going into. The more information you have, the better to be with your descriptions, and the more emotion you can take of it, the better. The more you understand that it's not a win or lose. You truly just have to think about how can we settle this? And settle sounds like such a bad word to us, but that's what our life is, especially right now during the pandemic. When are you getting any of this stuff heard? You got to be able to buck up these conversations and come to a solution that everybody's equally happy or equally unhappy, and everybody can move on.
So we've, in our roles, we understand that we have to stay in it until it's solved, and we don't have the privilege of being nasty to people and that sort of stuff. And so please do remember that the broker does want the best for you. They really do want to win it for you if they possibly can. But it's going to be, I was going to tell Nikki that the best case I ever saw documented, and it was in my hand in 7 days before they even closed escrow. We spoke to them. My agent backed out because of the wait. He just decided he didn't want to wait for it. And it was there was no delay in notifying. There was no delay in my notes. There was no delay in my text messages. They were texting at the property back and forth, terms, the whole bit. And I couldn't, and an offer got written, but it didn't get accepted, and they went on to something else. But the agent backed out over just waiting.
Well, and I thought of your broker. Sometimes when the broker tells you this is not a winner, then you got to understand that your broker's not a bad person. There are times that you open yourself to more exposure. One particular I had, it was $37,000 commission. The agent that ended up earning the commission gave away higher. Okay, that was the deal that he made with them. Doesn't, when we are in cause ring, guess what? Was what, and that broker didn't tell their agent that, look, you could be liable coming out of pocket for all of this. Fortunately, we were able to settle it. At the end of the day, fight for our agents doesn't always mean that you're going to take a case through. Sometimes saying, you know what, you have a lot of exposure here, and because you do everything right. Think about when you're driving the driver, also do wrong. You're fired. There's a lot that we can find. And so some is looking at that exposure and saying, I don't think it's worth it. And that is in your best interest. Not that they don't want to back you. They actually do have your back.
To further that thought, we already have to do that. And so it's been a part of what's just runs in our blood every day as a manager or a broker. But this year, because of this last 12 months with coronavirus, C.A.R has been really selling the message, and I'd like to have Nikki do it, that never has there been a better time to work it out right now, right? Can you say that better than I can?
Yeah, and this is actually something I preach to our clients every single day too. Got to think about negotiation. We don't get paid to fill out contracts, guys. Okay, he can do this, and we have a computer that does that. We really bring to the table is our experience, our knowledge base, and our ability to negotiate. There is not one answer to everything. Okay, there are a lot of different answers. You have to think outside the box and you have to propose other solutions. Just because your client wants A doesn't mean A is the only answer. You can say, all right, well, what do you give up? Because then you have something to negotiate with. I think that is that have adapted that over the pandemic have had a million years, and understanding that there is, my agents will call me and they go, is my client right? I'm like, well, seller has to leave, but what are you going to do? Are you going to pick them up and put them in a car? It's not going to happen. Now we have to negotiate a solution. What is that seller afraid of? How can we help around their whatever's holding them back so that our buyer moves forward? And I hear, not right. It's not right or wrong right now. It's finding a solution. And that's really where we have the opportunity to do amazing things for clients. Finding solutions, thinking outside the box, talking to your brokers, talking to other agents. What do you do? Turn out right. Okay, and you'll have all the different solutions that are available to you and can make it so that you can close your transactions and everybody can move their life.
We had a coronavirus situation happen that was going on. A buyer had lost their down payment and had financial setback from directly related to the coronavirus. And we were already saying that it was a major factor when the very first coronavirus form dropped at 8:30 at night, that particular night. And I rolled off the couch and rolled right over and wrote our paperwork up. And I'm in fact, the next day when C.A.R taught the class, I heard him discussing my situation because I honestly think I might have been the first one to get a coronavirus form out after it dropped. I think I had it in by 9 o'clock. The answer that I got from the seller was this: no. Was not contemplating a world pandemic event or any of the factors. Just no. Even their attorney called and said, and I thought an attorney should understand a major factor like this. But I mean, I had to start from, oh, no. So even with C.A.R's help and a good form and proper paperwork, I heard no. Now, of course, went the whole way and stood. And we did finally settle with the deposit. It took us about 6 months to get it.
Well, and I think you got and understand how the courts in California look at things. But the haves and the have-nots are very important in this courts in California. And this buyer was impacted by a worldwide pandemic, something that we haven't seen in over 100 years, and or could go through with their contract. Really, how do you think the court is going to look at that? And we have to be able to step back. I understand that this has been mentally draining on so many, but this is where we step up professionals, is the emotion out of it, and we paint the picture and set expectations. When you sit down with your seller, don't tell them they're going to close on November 3rd. If they close where a week before, a week after November 30th, that's a win, because you're in the pandemic. We have no idea what different regulations may be passed in the course of the transition. So everything is a guess. As soon as it gets closer, we'll be able to give you a better idea. But at this, understand that you're going through this, and we're going to hit some potholes. My job to get you through it. But set actions. You did deposit.
We're coming up to the hour now, and I don't want to keep making much longer than Nikki. Final thoughts for us, and then of course we're going to take questions just for a moment if you have a little bit of time for us.
Absolutely.
Any final thoughts?
I think just coming down to, we are all human and we need to work together. Okay, we've got court, got rules, I have contracts. I absolutely adore them, but right now they don't mean anything because it's hard to enforce anything. So that being said, this is where you really are being tested. You need to be smart. You need to talk to people. You need to look at solutions. Very, very solution oriented. And it's not the same old solutions. It's new and different. What does the other side need? What can I give them to make them understand and give me something from my side? It's all about negotiation and making sure that you're compromising.
I'm going to throw it out for questions now, but I really once again want to send out the sentiment that there is a path, that we know how to do it. We're willing to help you do it. We don't know what's in your head or in your text message or in your emails. We don't have the relationship with your client you have, and we very much rely on your participation in these cases to do them at all. We wouldn't even know they existed if you didn't ring the phone. So I want to, before we take questions, I just want to be very clear that we care and we want to fix it. Tommy, did we have any questions today?
I did not see anything in the chats as of yet. I will post both of these files in the chat. But yeah, there were no questions that were asked yet.
Anybody have a question? Just unmute yourself and throw it out there. Tommy, what do you think?
You know, I think the biggest takeaway is for the agents, your documentation means everything when something happens, right? You may not think about it when things are going smooth, but your text message conversations, your emails, your telephone conversations. In all honesty, I think many should limit the amount of conversations you have on the phone and more in writing, so that it is documented, or follow up with an email that says, hey, per our conversation, I just want to follow up, right? But keeping track of your documentation for the what if, when it does happen. Eventually, you may experience this. Not everybody will in their career, but a lot will.
Tommy, I had a question.
That plays a huge part, you know. The other thing that I took was you are in a situation right now where it wasn't always comfortable to ask for a buyer-broker agreement, right? That was kind of like the awkward conversation of, do you want to work with me? But if it gets to a point when you're showing houses and now that you have to send out a PEAT form, it's very easy lead in to be able to send a buyer-broker agreement and say, you know, this is what I need so that I can represent you, and, you know, my insurance then protects you. But without it, you know, we really don't have a contract of us working together, theoretically.
That's how I pitch buyer broker. I'm not going to go there now because we don't have the time, but that's how I pitch buyer brokers. It's your shopping list. My obligation to go.
You know, as Nikki mentioned, you're already sending them a PEAT form to sign. You know, for them to electronically sign a buyer broker agreement at the same exact time before you go see your first house is, you know, at that point should not be an issue with most buyers. Unless they're already working with somebody else doing the same thing.
You can do it with a single party, a single address at first, and then improve it as your relationship improves. We did have a question, but I can't see who it is because the name says iPhone.
Okay, so so it says, are texts just as credible as emails? I know for some companies, they suggest an email in writing. I will tell you that you should always be downloading your text message for every file and attaching it to your file. And there are apps out there that will allow you to download all your text conversations into a PDF. And then therefore, they are time date stamped. When it downloads into the PDF, it says the date, the time, everything that text message was sent and who sent it. And it shows the entire conversation just like your email trails would. So if you're not doing that, you need to be.
What are you
Well,
what are you seeing as I honestly, I have to be honest, and I'm out of the broker game now, so I'll just confess that I don't think I ever saw better than 20% compliance on good note taking. Um,
and one of the really interesting things now is, yes, you can submit your texts for evidence for CRE, but that being said, they'll collect your phone. They want your whole phone, not just text. So if you're going to use text as evidence, put your whole phone out there, which means all others to everyone else, and that's a private place for it. So my aim is you get anything in text material, then you go ahead and you can put the little envelope, forward it to an email, put it in an email, and that way. If you emails, what's funny, the DRE will not require your computer. They'll take emails, but if you are going to use text as evidence, they will require your phone. That's where we sit now.
and all those other messages where you maybe said they were a jerk is going to be
Right?
is going to be visible too. Just like we talk about in your, what we used to call paper files, but your final file, very often repeated behavior will show up across a bunch of files. So thinking that they're going to limit the scope of inquiry to a single file or a single incident is naive. When I teach, I tell people, you want to be able to sit in court and say, nope, I do it that same way every time, all the time, no other way. And because you're going to get cross-examined, you're going to have, people who are angry at you, trying to poke holes in everything you say. So certain systems. I will say for those agents whose files are collected on an electronic system, SkySoap and that sort of thing, they each have individual email addresses, and I have to tell you, once I became a broker, that's my religion now, is finding that email address and getting it in there. Because when the actual corporate lawyer would say, send me everything, I had the privilege of saying it's in there. I didn't have to go back and scramble. And I think that's what really causes a lot of failure in general is you're mad today, but you didn't take any notes and you didn't write down everything you did today. And now it's 6 months later and we have to think about what you did. So we used to teach agents way back to keep a diary, and I don't mean a diary, but a journal, and I don't quite mean a journal either, but a daily record of what your appointments were. So, because you might be able to prove that you didn't do something because you couldn't possibly have been there. You were, on your boat in Laughlin, that week, and you had no communication whatsoever during that time. So, records also prove sometimes what you didn't do.
Well, and when we really look at everything, keep talking to your people, be good to your people. I will tell you now, if your client likes you, they're not going to cheat on you and they're not going to sue you. Okay. What I found over 21 years, and like you're upfront and you're honest and you do your job and you do your best for them. So really, it's so hard at times, you're like yesterday, and then all of a sudden it's 4 and then schedule, have these conversations. How are you? Shoot them a text. I have a lot of agents that say, well, I think a text is impersonal. And I'm like, well, great. You haven't called them for 10 days. That's where we ran into a problem. So find ways to do it, whatever your system is. But I will say, people don't sue you and they don't. So, I'm not saying that we can control certain things, and that is our relationships. Those people, a lot of times, I'm sure you heard it too, MJ, an agent will come to me and say, I knew I was a slime. The first time I met it, like, well, why did you work with me? Make good choices and put yourself in a position that you can make good choices, because those are the people that are going to run the world.
I want to take 2 minutes and just go off topic here for a minute. For a second. Nikki, what's your passion project right now? Tell me about your committee for just a couple of minutes, and what's new with C.A.R right now?
So for 2021, chair of strategy advisory. And this is one of my favorites because we get to meet all the attorneys that work with C.A.R. across the state of California. Attorneys only defend brokers, so they're all in our boats, and they go through and test what kind of things they're seeing, what they know companies, who's leaving the state, what we need to be careful of, you know, all of those things, what denied and what buyers are saying, what has suddenly started. I got the impacts. I had no idea, and I tell my agents now, unless you want to give up your phone and picture, you want to make sure you send everything to an email. So it's basically 3 hours that we all sit there and get what claims are really being filed, seeing what courts are open, and who has actually had a vision on anything relating to the pandemic, because we definitely are looking at that. Not sure how these things are going to shape up. So it's really, the first time I sat on that committee, I walked out of the room and I'm like, why am I in this business? Because it was literally 3 hours of all the things you could do wrong. And you at it and you have to flip the script and say, okay, what can we put in place to avoid these? And to make people aware. Agents won't do things that are risky if they know it's risky. But if they don't know, then there you go. So it's definitely more from an educational perspective now. And of course, I like stuff because it's an idea. I'm very, very literal and analytical. So I like writing. And that's just the way my brain works. And it really takes me to a place where I have to go, okay, right and wrong really don't have a place, not in California. Sorry, they just don't. It's all the mitigating factors in between. So you have to look at the whole picture, document everything you can, and make sure it's truly practice. You've got to make sure that you're dotting, crossing your T's.
There was one question that came through. It said, I had a question about the litigation between Zip Forms and Glide. Did anyone else get that email? Does this mean
Pretty much the whole world, I think.
complete
Yeah.
transactions entirely?
At the end of the question, I mean what?
It says about the litigation between Zip Forms and Glide. Does this mean that we can use Glide now to complete transactions entirely?
Actually, that's being released at the end of the month. So I do have actually a webinar for a service or one of my cases that I'm on that'll teach us how to do that. And you are going to be able to do it out of the MLS to be able to write an offer using Glide forms. So now it's all launching at the end, and it was interesting that the lawsuit came through. So we'll see how that all shapes out. But right now, the plan is that you will be able to do that, and you will have that ability by the end of January.
As much as I like Glide, I'm not comfortable with having no procedure for not warning people that they're going to be solicited for the insurance. I did already put on our topics to go over this entire subject, and I won't drag Nikki down the road with us on this one. But that is, we have 2 transaction coordinator groups that work with us. Nikki, one has 1,000 members, one has 600, and this is an endless conversation right now.
Agents can opt out. Agents just have to go to their profile and say that you want nobody contacted, and you click the boxes, and then anytime you're in your systems, even through Glide, they can't do it because it all goes through your zip form preferences. But it is an active thing to go in and opt out. So you go into your preferences and you go into, I think it's advertisements, and then you'll see different companies, and you opt out of each and every one of them, and then your clients will never see that.
Is it an appropriate concern that they're being solicited without any warning? Or
yeah, I'll tell you, I was annoyed because I'm sending stuff to my clients, and my clients trust me, And if I wanted you to have my client's information, I'd give you my client's information. But when I went in to opt out, all of mine were already done. And so, you know, I started talking to my agents, and some of theirs were and some of them weren't. But I think it's just an important thing for you to get in front of your agents and say, you need to go in and do this. Otherwise, this could happen. I think it's crappy that C.A.R. allowed it to happen. But that being said, they did sell the company. Now it belongs to Lone Wolf. And so when we talk about zip forms issues, C.A.R. doesn't have say anymore. Now it's a Lone Wolf thing. And yes, it was our data, but at the end of the day, we sold it. So
We're in an
gotta know
evolving,
that stuff.
we're in an evolving profession. There's always going to be changes. There's no avoiding that. But sometimes you have to decide what you pick up and put down. Since we're running at an hour and 10 minutes, I would like, Nikki, you're welcome to stay or not stay. Tommy and I stay on until everybody's off and just make sure everything's settled. Thank you all for being with us today. Please think of Granite Escrow as a problem-solving solution for you. We do talk about transactions that aren't ours in a very general way and send you back to your broker with some solutions to discuss. And you know, and of course in coronavirus, we're doing the mobile notaries, porch notaries and all that and stuff is at no charge. So we hope you'll think of us. Nikki, as always, outstanding to have you. I think you guys are looking at a future C.A.R president here. And I hope you
Live.
Yeah.
Thank you very much. It was very, very nice to be able to join you all and talk about this. I think that these kind of conversations just make us all better.
All right. Well, thank you, everyone. If you want to stay on and chat or have a question
Thank you.
here for a minute, thank you again.
Appreciate everybody. Have a great day.
We will shoot you the
Yes.
recording, Nikki, in an hour or so.